Stuart.
Hey,
Greetings.
Jill. Hey, Jill.
We had interesting morning, basically torrential rain. I'm just honoring the fact that we do have a guest here today, and the effort she made to get here is really appreciated. Brooke Christy, who is the Equal Justice Works Fellow at Fair Shake Environmental Legal Services. And I just want to first state that I have almost a decade of incredible collaboration with this fantastic organization who provides tremendous support to individuals who are dealing with the impacts from the oil and gas industry. And so Brooke Christy, again, Andrew Early, and Addison Caruso have been supporting Stuart and I in exposure during, this development of our media campaign by, reviewing our episodes and making sure that we are speaking in terms that will uplift our cause and the truth, but also eliminate risk of, I'll just name it, SLAPP suits from the industry.
Mm-hmm.
And so in part, Brooke's here to talk to us about that today. First, I want to say thank you so much. The peace of mind that your efforts and support and reviews have given us is so valued, and we're really grateful to you and your team.
Yeah. Well, thanks so much for having me, and thank you both so much for all the advocacy work that you do. I mean, having clients like you all really is what keeps us going. A little bit about Fair Shake, just before I begin. We are a nonprofit environmental law firm, and really at the center of our mission is to make sure everybody has equal access to environmental justice. So we offer direct legal counsel on a sliding scale. So it's always based on income, and roughly about 60% of the clients we serve, we offer pro bono, so free legal services.
And you did that for me early on with a compressor station that I was dealing with that had been an ongoing and significant violations of the Clean Air Act and the Ohio Pollution Control Act, and that's when I met Megan Hunter and James Icecamp.
Yeah.
It's great.
And then we also recognize that too often people call us after they've already been harmed, right? You already had that compressor station in your community. And so we have developed a whole nother component of our nonprofit, which is the Community Democracy Program, aimed at providing free technical assistance to communities that are just trying to pull those levers of change. So it might be like helping figure out who is the best person do I contact about this development going in? How do I comment in a way that could allow a lawyer to help me in the future bring a lawsuit and so forth. And so, today is an example of that Community Democracy Program, getting out, sharing a little bit about how do I mitigate the risk of SLAPP suit, because it's really hard to eliminate the risk entirely, but there are ways that we can better protect ourselves and mitigate that risk within the advocacy space.
And so before we began, you gave me a little tidbit about your past and how you ended up sitting here today. So will you share that, please?
Yeah. So my family is from the Pittsburgh region. My dad, even briefly worked in steel mills. And so when I decided that I wanted to go to law school, I definitely wanted to come back to the Pennsylvania region. And, picking University of Pittsburgh was big on my list because of Fair Shake's presence in the area. A lot of legal work that we get into within environmental law is often mission-centered, like it must be clean air, clean water that these lawyers are working on. But Fair Shake is different in that we're community-centered. We don't pick a cause that we fight for. We listen to communities and we fight for whatever cause is top of mind for them. And having lived in rural communities, most of my life, that was really important to me, that community voices are centered. And so, I picked University of Pittsburgh for various reasons, but one of which was definitely the presence of Fair Shake and wanting to make sure that I was trying to find my way to work here at post-graduation.
How did you know about Fair Shake at that stage in your life?
It was really just Googling. The founder of Fair Shake used to be the director for the Environmental Legal Clinic at Pitt. So it was just a natural way to have found this organization through Googling.
And so it sounds like a lot of your clients are just individual community members, or do you get like townships that come to you or municipalities? How does that, what I guess, what's the diversity of your client base look like?
Yeah, so it varies a lot. We have a lot of organizational clients, we have individuals, and we also have coalitions. We do sometimes work with townships and municipalities. Typically, they'll reach out with interest in some legal research or model ordinances work that we've done. And so we'll serve in like a informal consultation capacity that way.
Nice.
And what's your range geographically?
So our mission allows us to serve the entire Appalachian Basin, but we only have attorneys in Pennsylvania, Ohio, and West Virginia. And we do have a heavy focus in the Ohio River Valley area. That is primarily because of the large industrial operations there, as well as we see it as an area of extreme need for legal support.
So true.
Mm-hmm.
And so Jill mentioned it, SLAPP suits. We kind of want to talk about that today. I think it's important for people to realize what they are. And there's not a ton of, John Oliver did a segment on SLAPP suits that I thought was very good. But beyond that, I can't think of much else out there that's really explained to the public what a SLAPP suit is. So from the horse's mouth.
and like SLAPP suit.
What does that even mean?
Yeah, what does that stand for?
Yeah, so SLAPP suit stands for Strategic Lawsuits Against Public Participation. And essentially, in layman's terms, that just means it's a lawsuit that is really brought just to, chill the advocacy and disincentivize people from speaking out. And the way that they're able to do that is they will bring a lawsuit that is likely has very little merit and extend it through intensive discovery or even appeals and keep that person who dared speak out tied up in legal fees and costly litigation. And so, majority of states have taken a stance against this and passed what we call anti-SLAPP legislation, but there's about 20 states that haven't, and West Virginia is one of them. So within our region, we still have persons that are fearful of SLAPP suits. Ohio just recently joined as the 35th state to pass anti-SLAPP legislation, so that's very new. We're excited to see it, but it has definitely been a top-of-mind concern for a lot of the advocates within the Ohio River Valley.
And so to be clear, it's a weaponizing of the civil litigation process, because civil litigation is not a fun process to, even when it's done correctly, right? It's very lengthy. There's stages. And so what happens in a SLAPP suit? An industry or a company who is trying to silence dissent or concern kind of pulls somebody into that civil litigation process and makes that the, punitive mechanism.
But can I just interrupt to say it could also be an individual against an individual? It doesn't just have to be a company or an organization, right? Yeah. Yeah,
so typically when we see SLAPP suits, they'll allege things like defamation, tortious interference with a contract. So they're arguing that you have defamed them in some way and that they may have some damages from it, whether that's their reputational damages or loss of a contract. So whether you're calling out a person, an organization, or entity, if it's a matter of public importance, you're allowed to do that. So that is your First Amendment right, but they still have the right to sue you, arguing that you went beyond what was lawful. And so that's where this discrepancy comes into play, and they can keep you in court tied up in extensive discovery on, what was your intent in making these statements? Was it actual malice? And that will result in costly legal fees. So just as an example of that, we had a West Virginia coal executive who sued John Oliver for statements made on his episode. But yeah, John Oliver said things in his show like called him a geriatric Dr. Evil and had a giant scroll named Mr. Nutter Butter tell Bob Murray to eat shit. And these are all very clearly opinions, right? That you are allowed to have, like, saying things about how he looks. But regardless, they spent over $200,000 in legal fees defending their right to have a personal opinion, making fun of this man. And so that just goes to show how even the most egregious statements, which are very clearly a personal opinion, and even the most wealthy, such as, like HBO, stood behind John Oliver and his statements, still had to expend $200,000 to protect themselves.
And so you can imagine a small nonprofit
Exactly.
with
Yes.
limited funds could just be completely wiped off the map through something like that.
And we've seen that before. So like another example of that, one of the most famous ones is in Colorado. There was a SLAPP suit against a nonprofit coalition group that was called Protect Our Mountain Environment. They went to stop something like a 507-acre development project. They did lose their suit, but regardless, developers wanted to kind of prove a point that you shouldn't mess with us and our projects, sued them in court, saying that they abused the civil process trying to challenge them, demanded over $400 million in damages. It took over 40 years. The development was never built, so, the group succeeded in their advocacy in some ways, but basically, the group's nickname is POEM. It has slowly been dismantled because of the extensive legal fees and also the fear that it created in speaking up. And, just to give a more regional example, we also had Bob Murray, same coal executive, initiated a SLAPP suit alleging defamation, false light, and invasion of privacy against a Huffington Post and a journalist named Mr. Stark. So the article that the journalist wrote was called Meet the Extremist Coal Baron Bankrolling Ken Cuccinelli's Campaign. That was very clearly listed as an opinion piece and released in the Huffington Post, and yet they still sued for, of course, defamation, false light, and invasion of privacy. The ACLU did step up and defend Mr. Stark, the journalist, but it costs legal fees to do that, right? And even the judge in the opinion talked about how the Huffington Post had removed a lot of articles which mentioned him out of fear of further retaliation. And so that is typically the intent of these cases, is to chill advocacy and scare people from speaking out.
So, Brooke, what standards do the courts use to determine if it's defamation or not?
Well, in every SLAPP suit, you have a couple defenses to make. That, you do have a right to freedom of speech, freedom of expression. And of course, within that, any statement that you might make which allegedly defames somebody, if it's true, then it's true. So truth is a defense.
Right.
What do courts consider? Well, they'll also consider if you're criticizing public officials or matters of public concern. So making sure that you're always tying it back to something like that. So a public official made a decision to allow this development. That is pretty clearly within, your right of freedom of speech and to petition your government for change. If it's a matter involving public importance and maybe some private entities like an oil and gas company, coming into town and trying to either negotiate for deals with private landowners or so forth, you can keep talking about why these private persons or private companies are impacting things of public concern, whether that's your concern over, the permit process or water pollution, air pollution, so forth. Just make sure you're always tying it back. Because the court's biggest concerns is when you're talking about private persons, private companies, and they think there might be actual malice involved. That you're not really concerned about the public importance factor, that you're actually just maliciously trying to take down these private persons or companies. So what do they think about? Actual malice is defined as knowingly making a false statement or speaking or acting without regard whether they are speaking the truth. So
Right.
if you are, consciously trying to fact check yourself and make sure that you're speaking with the most up-to-date things while you're calling on legislators or private persons to make the right decision, you're going to be more protected in court than had you not.
And see, this brings me back to, I'd say, truth as the ultimate protection. And that's where I've stayed. That's the core of everything I've done the last, 15 years. And fortunately, I had the inner knowing in the beginning that I needed backup, and that's why I started and was encouraged and um, led to researchers and, like Dr. Nicole Diesel from Yale. She was here 10 years ago. I mean, I knew I needed backup. And yes, I can research and find the facts, but also supporting and encouraging research and community science as protection in the truth. Right. So that's a really good point. Like, do your homework. I don't know how else to say it. And be prepared with the data, with the facts, with the truth, when or if you might need it. Right?
Yeah. And I think being prepared is a great point, because you could take all these steps to mitigate the potential risk of a SLAPP suit and still get one, especially in places like West Virginia where there's no anti-SLAPP legislation. But if you have, those citations and just kind of any informal way that you've documented your research and what you've relied on in making these statements, then it's easier for an attorney like, us or ACLU or whoever might step up to provide some legal counsel that we can better defend you more quickly.
I guess I don't know if this is the right time, but I guess what are the risks? Like, so let's just use us as should we use us as an example?
I don't want to do that. I feel like that's bad energy.
Okay, all right. What I was trying to get to is, what are the risks? Like, so, I mean, there's always a potential. It's a SLAPP suit. It's frivolous. But maybe you get a judge who is pro this or that. I don't want to say industry, but what if they're pro-industry? And are there circumstances when, even though it's frivolous, it's ultimately up to the judge, right? To the courts to decide. And, like, I guess, do we want to talk about what could happen if, you lost the case?
Yes, we can talk about that. So you mentioned that it's up to the judges, but the judges also have to follow the law.
Okay.
So in states, and again, going to compare West Virginia to Ohio and Pennsylvania, they have a lot less discretion to dismiss early. They really can't. They have to allow for that discovery process. And that's why these are such, scary tactics to be used by energy companies, as an example, or whoever it might be, is because you get tied up regardless of what discretion the judge has. Actually, I think a scarier example is you do win very quickly, even in maybe, or after all this fight, let's say you go through a case in West Virginia, you win after all that extensive discovery and legal fees, they're just going to appeal it.
Right.
And so I think that's the more scary.
Then.
Yeah, I mean, it's just a continuous appeal until you get to a more, neutral arbiter that protects freedom of speech. I think one of the most scary examples right now is the Greenpeace case.
Yes.
Yeah, which has, I'll just say, a lot of anomalies in it right now. And so it'll be interesting to see what happens on appeal. But you had a case within a very small jurisdiction award $600 and I believe $60 million against Greenpeace, finding them liable for several counts, including defamation, tortious interference with a contract, I believe, and others.
For the Dakota Access Pipeline
Correct.
fight.
Correct.
Right.
Mm-hmm.
But I guess for me, as a small, nonprofit, like, I just hope that folks like Fair Shake and others, like, if we can stick together and that we'll have backup, Does that make sense?
Mm-hmm. Absolutely. It's such a cultural norm to keep speaking out, right? And so if we keep doing so collectively, it doesn't mean that, some of us won't be sued for SLAPP suits, but it makes it less likely if we're staying together as a collective. And, the stories you just shared, you're speaking from your truth. And so that helps. And from your experience, you admit things that you didn't know. You talked about facts that you did know.
Right.
That's really important when considering, what you're saying while speaking out. It doesn't mean that we don't have to back down. We don't have to censor everything that we say, but we should be conscious and mindful about what we say so that we don't give them more ammo than they need.
Okay, so I'm going to use this as an example. So for clarity purpose. So in that story I just shared, if I would have said, and I'm not saying this, this is as an example say, Energy Transfer sent guys to follow us, and they were taking pictures, and they were trying to intimidate us, and that's where the problem would be.
Yeah, that would be an extreme problem.
I said, I don't know if it was them or who sent them or who the guy worked for. I just know somebody was there. And I can think and have an idea, but that's the difference, right?
That is a big difference. And also to the extent that you could maybe have evidence to support your statements so that it doesn't just become he said, she said in court, right? So if you had pictures of that spill as an example, that would be more evidence to support that you weren't just recklessly making these statements. You have some evidence to support what you're saying. And because we know that, corporate companies keep a lot of records. Whether or not they're always accurate is a whole nother debate, and why they'll sometimes get in trouble for maybe notice of violations and so forth. But they have records to support their statements almost always. And so we should constantly be thinking about, well, what records can I keep to support my statements? What pictures can I take when I see something weird going on, or I see, exhaust from a local development site that looks a funny color, or, has a weird smell or symptoms, in my community from it.
So meaning, say, I smell an odor, close to town. I go out and there's a flare at a pad, and I see the smoke coming off. So instead of posting on social media, there's a pad, it's making us sick, and there were fumes coming, there was smoke coming off of it. Having the video to show along with that, you're way more protected than just making a statement.
And you can make these statements. Again, truth is always a defense. But when it comes to how well can we defend you in court, or maybe get something dismissed, if you had a video evidence and you're in a state like Ohio where we could get request a motion for early dismissal to show that you weren't maliciously making these statements, right? These are just considerations. You still have the right to freedom of speech, but again, this is a legal intimidation tactic. So how can we push back in the courts faster? Having records.
And that's possible in Ohio because Ohio has anti-SLAPP suits to get it early. So you can enter in a motion to dismiss earlier based on anti-SLAPP suit legislation than you can in a state like West Virginia, where they're going to make you go through the whole process of pleading and discovery and all of that.
Correct. And if your motion is denied, you have the right to immediate appeal. And so that's, again, why these are such important statutes to have on the books in states. Would love to see a federal one, too, because if we don't have it in every state and we don't have it federally, it allows people to forum shop. Right now, they are suing people in states that don't have anti-SLAPP legislation, like West Virginia and previously Ohio. But, if the states keep passing them, they also could just bring suit in federal court. And federal courts disagree on whether or not states' anti-SLAPP legislations apply. There's this concept in federal court where if it's a substantive law, we'll apply the state law. But if it's a procedural thing, we have our own procedures. We don't have to follow the state procedures. So they disagree on whether anti-SLAPP legislation is procedural or substantive. We don't have a clear answer yet in this region, in the Ohio River Valley, of what our federal courts would do here. But good news is Ohio attempted to address that question. And within their anti-SLAPP legislation, they do have language which basically instructs the federal courts, or attempts to anyways, have them apply it as a substantive protection.
And
Nice.
they can venue or forum shop in other states too, right? Like if just because you're operating in Pennsylvania doesn't mean they can't sue you in Texas or West Virginia
Is
or
that true?
someplace, right?
Slightly. You still have to have a standing and personal jurisdiction in these areas. So you would have to have something that would like bring you to that jurisdiction. So I believe, and I don't know this to be certain, but like the John Oliver case as an example, clearly John Oliver does not live in West Virginia. And actually the coal executive, Bob Murray, does not live there either. But he sued there, and I believe it was because the actions which John Oliver was talking about occurred in West Virginia.
I see.
And so that's why he was able to argue that, substantial events in regards to this case occurred here and brings us here.
So they have to have some reason to link it to a location. But if they can find that reason, they will, if there's no SLAPP legislation, no anti-SLAPP legislation there.
Yeah, it incentivizes them to try to
preferable.
find that reason. Yeah, of course.
The common triggers for SLAPP suits, obviously, if you're working in like the NGO space, in journalism, in advocacy, you're kind of going to be more exposed to these. But individuals can get SLAPP suits brought against them as well. If you go and just, like, how does that happen? If you go speak at a town hall or something against a project, can they throw a SLAPP suit on you?
They could. I believe it was ACLU Ohio who collected some data on how SLAPP suits are typically provoked. So their numbers were 47% participation at a public hearing, 20% filing public interest litigation, 18% reporting violations of laws or regulations, 8% lodging formal government complaints, and 3% peaceful protests and legal boycotts. I believe those numbers came out years ago, so they may be shifting a little more. Like, I wouldn't be surprised if we saw peaceful protests being a higher percentage nowadays. But yeah, I mean, all these are lawful ways to petition your government for change, right? And ways that we address matters of public importance. It is your right to continue to do so. But, one of the things I often hear most, I would say, that causes concern for SLAPP litigation is allegations of corruption without proof. So if you're alleging that, I know this company donated this much to their campaign, and that way you're clearly stating what corruption that you're talking about, you can still say that that's a form of corruption. But to, say it's very nefarious without any evidence is very high risk of SLAPP suit.
So can you just explain those breakdowns, like what they are? So peaceful protest, boycott, that's pretty obvious. Formal complaints, like what would that be?
I'm not sure why they separated out formal government complaints or reporting violations. I would probably loop them together a little more. I would see them as, taking a picture of some illegal, discharge in a stream and sending that to your Department of Environmental Protection.
So like that's something like that just seems to me to be just something that would just automatically, like, no judge would say that this is problematic. How is that? Because
the procedures didn't allow them to dismiss it early, right? The judge could be sitting there the whole time knowing that this is a SLAPP suit and it was your lawful right to report something, but they have to allow the case to be seen through. And so that's why the anti-SLAPP legislation is so important, is because it allows a judge who's sitting there knowing that this is procedurally wrong to dismiss it.
Okay, but so then I see a discharge in the Ohio River that's coming from an industrial site. I take a photograph. I send that photograph along with a complaint to the regulators, Ohio EPA, Ohio Department of Natural Resources, and say that I don't post that on social media. I don't do anything other than send it to the agencies. The company can do a FOIA. How would the company find out? They do a FOIA request, a public information request, and find that out, and that's when they do a SLAPP suit? That's where does that happen, or is it just more I make a complaint to EPA, but then I also go public with it and maybe go to a commissioner's meeting and the news covers it. Is that more likely the case?
I think that's more likely when they're concerned, right? Corporations are still very worried about their profit and perception.
Public opinion.
So, if you're making a huge ruckus about it and going to all these meetings, going to the news, I think that's when they're more likely to be concerned about an allegation rather than it just being a report. But, I want to emphasize that even though we do see these and they're scary, more often than not, I see people speak out and have no repercussions, right?
This is America, and we have the right to speak.
Because it is your First Amendment right, and we see less SLAPP suits than we see more productive results from, using your First Amendment freedom of speech.
Okay, so on that note, one of the first things you and Andrew and Addison provided for us was a document to share with our guests. First for us to review and then to share with our guests before they came on the podcast, and basically outlining.
Did we give that to you?
Oh, I haven't.
She wrote it, Stuart. No, but the point is, like, we're not trying to censor anybody. We're not trying to, like, do anything other than provide you provided us a template with, here's the best way to say things to eliminate the risk of SLAPP suits or getting into trouble. And so can you provide us some of those
tips,
pointers? Yeah.
So I would say, number one, stick to the facts and avoid broad generalizations. So, people sometimes when they're very emotional say they always do this or they never tell the truth. It's very rare that something is always or never true, right? Say, instead make it your experience that every time that I've interacted with them, this is what I've seen, or they failed to live up to the promises that they made to our community. These are very powerful statements still, but you're not using the word always or never. It's very hard to defend against an always or never statement.
Good point.
Another one is, we've already talked about it a little bit, but cite to your sources or at least keep a record of them on the side for yourself. I think being open about where you're getting your information disincentivizes those companies or persons to sue you because they know you've already done your research.
Nice.
It won't be a foolproof way to stop it, but I think just being transparent about what information you're relying on. And I also think that adds to credibility to the audience you're speaking to, right? If they know that, you're calling on them for these permit violations, then they see you as a credible source for more advocacy and awareness in the future. So another tactic is make sure that you're expressly obvious about when it is a personal opinion. Include things like I think, we suspect, I'm concerned, or believe this. And just an example of verbiage, instead of saying something like this company is evil, say I think this company has serious ethical concerns, and then talk about what you're concerned about. And another point, which we've already talked about a little bit, but is expressly state when this is a matter of public concern. Always loop it back to a government decision or some type of awareness about community health that you're concerned about, and that helps us argue, again, this is not actual malice. This is all driven, this freedom of speech, out of this concern of something of public importance. And then last but not least, make sure you have insurance to help cover costs. So whether you're a person, you can go check on your homeowner's insurance to see if they have any protections for libel and defamation. And if you're an organization, you can also check your insurance to make sure you have some sort of media liability that will cover defamation costs as well. John Oliver talked very openly about how his insurance did cover some of the costs. It also increased his rates, but of course, that was a $200,000 legal fee, so it's really important to have some sort of help in that space.
Meaning that homeowners insurance potentially would have...
Potentially.
I didn't
You'd have
know
to
that.
check your coverage, yeah.
That's good to know.
And Fair Shake, we will be releasing a guidebook that we can provide to community partners to help them find resources like that. I'm not any insurance expert, but we have found some resources that can help you navigate talking to your insurance companies and trying to make sure you have that coverage.
So I guess what I want people to understand about SLAPP suits is that this is essentially a form of censorship. There's a lot of focus, particularly in this last election, about being censored on platforms like X, Twitter, or whatever. And typically a lot of that has been, in my view, like, the statements that were supposedly censored were pretty frivolous in the first place. Facebook posts, I see a lot of people on Facebook saying that their posts have been taken down and such. But this is like really damaging, dangerous version of censorship. And I feel like people really need to understand that the most egregious forms of censorship are happening, in the courtrooms. And it's the civil litigation process being weaponized against people who are doing good work, good journalism, good advocacy, trying to protect communities and the environment, and they're being silenced, in some cases permanently, by the interests that they are speaking out against.
Yeah, I mean, we know that President Trump has said statements before on stage about how he would like to open up libel laws to make it easier to sue, people who are speaking out. And we also know that, there's several statements from founding fathers and others that talk about why the freedom of speech is the First Amendment, because it is the guard of all the others. How can we ensure all our other rights if we're not allowed to speak openly and honestly? Frederick Douglass famously said something along the lines of that the freedom of speech in the First Amendment is the first one that tyrants attack, because they know how much it's worth and how it is the guard of all our other rights. And so I think that's something really important to think about. And we may be faced with risks when we're especially, leading different advocacy causes. But, some people will say that you exercise your freedom of speech at your own peril, but you also stay silent at your own peril.
Exactly.
So that's why it's so important that we continue to organize collectively, that we don't just sacrifice one person or organization to be the leading cause, but if we're all there together, we decrease the chances of being met with a SLAPP suit.
Yeah, and I think it's also important for people to understand that the SLAPP suit itself, so if there's a SLAPP suit brought against a specific organization, that's only kind of part of the goal of the SLAPP suit. The rest of the goal is to have this chilling effect across the whole space of other organizations speaking against the same issue.
Exactly, to make an example out of them.
But here's a question. If you work for an organization, is it more, and there is potential that the SLAPP suit is not brought against the organization that you work for, but potentially against yourself, against the individual. And how often does that happen? And I don't know. How different is that? I don't know. I just wanted to make that clear. I mean, it's possible that you work for an organization, but that you're targeted as an individual, not as the organization, right?
Yeah, so that does happen. I mean, we saw John Oliver personally named in the SLAPP suit as an example. And I think that gets into a question of whether or not your employer will, what we call, indemnify you when you're doing things within your work. If you are out speaking in your formal capacity as an employee, arguably you should have some sort of workforce contract with your employer where they agree to protect you for anything that is within the bounds of your work. So that is, something to think about and maybe talk, especially if you're working in a nonprofit where you are out doing advocacy work all the time, to have some sort of agreement in place and make sure that that nonprofit has the insurance that we talked about as well.
And I'm just going to say it. It would be also to take that a step further, and if there are funders who give nonprofits funding to do specific things, and that nonprofit gets a SLAPP suit for those activities, that the funder would back them up. Have you ever heard of contracts like that between the funders and the nonprofits?
I'm sure that they exist. I have not necessarily, but yeah, I mean, that would be a great conversation to have. And I will say that I think that more and more funders are looking for different ways to resist, the environmental attempts at environmental deregulation that we're seeing. So I think that would be a productive conversation to have.
Nice.
What do you make of something we were talking about earlier in the conversation? You know, you were talking about making sure your statements are backed up with data, citations, and what do you make of these laws that are sort of being pushed? I think one's on the book in Louisiana where they're trying to make it essentially illegal for community organizations or individuals to use air monitoring to collect data.
That's in West Virginia.
I haven't seen that.
Yeah, that's in West Virginia.
And to have that data be used for like policy reform and things. So if we are supposed to back ourselves up with data, but then there's this active push to kind of undermine our ability to collect data and get that kind of research, what do you make of those laws? Is that something that everyone should be concerned about as well?
Yeah, I haven't read those laws, so I can't speak directly to them, but it does sound like it would still be lawful to collect the data, just not lawful for the government to rely on it in permit decision making. Is that true?
Yes, but it also
criminalize it or
in
something?
Louisiana, I think it does go a little further, and I think it, you know, and I'm just saying I think that this is how it is. It sounds like it could be used as a trigger for SLAPP suits as well, because they've kind of framed personal air monitoring as something that is like
Creating false alarm, potentially. I don't know because I haven't reviewed those ones, but I will say it's my personal opinion that I think anything that attempts to limit a community's ability to oversee, you know, private or government operations, I think is egregious. I think it's on all of us as a community to ensure that we're safeguarding our right to a clean, safe, healthy environment. And so to decrease that kind of public participation at a time when we already don't have enough is egregious. But that's my personal opinion. I don't know what those laws say to be exact, but I think we should be encouraging community oversight, and how community, you know, science plays a role in government decision making. I think we can debate about that all day, but simply trying to take it away would be a bad decision.
Agreed. I think that law is being challenged.
I hope.
Another tip that I'll mention is, you know, when you are doing your research, be cautious about just restating things that you've heard, even if you have record that, you know, X person said this statement. You can actually be held liable for, you know, perpetuating false information. So again, you know, when you're thinking about the resources that you're relying on, make sure it's more of like a primary resource, not just somebody's opinion.
I think one of the things that disturbs me the most is that the highest percentage of triggers is at public hearings, because I feel like that is sort of like what civics is built on.
Right.
Like we're supposed to be. The biggest complaint I've heard my whole life is that more people aren't involved. Right? Like not enough people go to town hall meetings and things. We want more civic engagement, not less. And so the fact that the highest percentage of SLAPP suit triggers comes from that kind of participation really is troubling to me.
Absolutely.
If I had to guess why, it's because you've confronted the person you're defaming right there in person, right? And so they're going to be more likely to have that visceral reaction of feeling offended and follow up on it with a SLAPP suit. So if I had to guess, that's why. It doesn't excuse the behavior. Of course, I agree with you. We should, you know, as a elected official or a public servant, you have put yourself in the public space and are beholden to the constituents that you serve. So
do you see a lot of SLAPP suits coming from politicians, or is it mostly from like the private sector?
I don't have the data on that, so I don't know, but I would say that it's easier for private persons to bring a SLAPP suit rather than a public official, because you have put yourself in the eye of the public, and you do, you know, make decisions of matters of important public public importance. Then you have a much higher bar to meet than somebody who's a private person, which is why it is arguably easier for these folks that work in coal or oil and gas companies, because they can argue that they're a private person if you talk about them as an individual. And so, if you do talk about them as an individual, talk about why. What decision did they make that impacted the community or public? Why are you calling out them specifically and not just the company as an entity? And that can help, decrease the risk of SLAPP suit.
It seems like something, though, too, where, it's kind of like if I say something about the CEO of a company, they'll use that as an excuse to throw a SLAPP suit at me.
I think it would be helpful to, especially, folks who are listening who might live in the shale fields or have, industries in their communities that they're concerned about, like, to maybe can you give some examples of what you could help people with or when it would be appropriate to reach out to Fair Shake?
Yeah. So Fair Shake provides general counsel to nonprofits, as an example. That might be like assistance in coming into compliance with IRS or state regulations. For example, we have helped people like draft bylaws and conflict of interest policies, and making sure that you have procedures in place for just nonprofit governance in general, we're happy to assist with. And in that, you might have want help drafting a media policy for types of outreach and what committee is going to lead that. That can all be in your bylaws so that you have the structure in place for the public advocacy that you want to do. And so then following that, once you have, more like persons that are going to be identified as continuing to do this outreach, we're also happy to help them. As an example, reviewing public statements that they're going to make, like speeches, and maybe recommending some changes just to decrease that risk of SLAPP suit. And we can do that same service, for individuals as well. If you're just an individual who wants to go speak at a rally or a public hearing, we're happy to do those reviews as well.
Nice. And then what about folks that are getting approached by an oil and gas company and they're considered leasing? Do you also review leases or provide support in that way and help provide them with input they need to help make these type of decisions?
Absolutely. So that's been primarily the work that Fair Shake has done for over a decade, is helping folks interact with oil and gas operations in the Ohio River Valley. So if you're approached and you either want to sell but you're unsure of the benefits that they're giving you, or you don't want to and you want to fight back, those are the types of services that we help folks in the region.
And also folks who say, like in my case, I had a compressor station that we were sick, my neighbors were sick. We had an idea, we thought it was coming from there. We'd gotten FLIR images from earthworks, could see the pollution coming off the facility. And so folks who feel like they're being harmed from infrastructure sites, they can also come to you.
Yeah, we're pretty broad in what we do because, again, we're not centered around a mission. We're centered around supporting communities. So we're not going to come in and say what's best for your community when it comes to an environmental issue. What we're going to do is listen and then ask, okay, how can we help? So that might be contract review. That might be helping you prep your speech for a public hearing. It really varies a lot. And we're just happy to meet the communities where they are. And do the legal research that we need to do to make sure we're serving as best counsel.
And we should say too, it's not exclusive to oil and gas. I mean, that's kind of what we're talking about. But any environmental law, logging, coal, tree law.
I tend to do some abstract stuff on the team. So recently I assisted a community group approached me. They had been impacted by lead exposure before, so that was part of what bonded us. And I have worked with families that have been exposed to lead, but primarily by paint. And so they said, well, what about by water? And I said, well, it's not my area of specialty, but I'm happy to help. They were interested in leading a ballot referendum to prohibit the sale of Pittsburgh's water system to a private company. And they were very passionate about this because the last time we had private management of our water systems, there was some increased exposure in lead. The private company never took fault for it, but they did settle with the city. So the community group was understandably, very scared for a future sale. And so I helped them navigate the process of what would a ballot referendum look like, who should you talk to about it. And they were able to approach city council, get unanimous support, And we got it on the ballot, and it did pass this past election.
Congratulations.
Yeah.
Nice.
So
Fantastic.
Pittsburgh water will be protected from private sale, through our home rule charter.
Nice.
Very cool.
Yeah.
That's
So-
great news.
Yeah. So that's just an example of how, community group had a concern, and even though it wasn't our area of specialty, we were able to do the work that was necessary, the legal research, to make sure that we were supporting them in whatever capacity that we could.
And so if other community groups or individuals, nonprofits want to reach out or find out more, how do they find you?
Our website, it's fairshake-els.org. We have our phone number and email listed on there, as well as a contact form. And so any of those work. I don't know the number off the top of my head, but
We can put it in our show notes.
yeah.
And are there any other last thoughts or points you'd like to make?
No, just that, SLAPP suits can be a scary risk. But like I said earlier, we have the right to freedom of speech. And the only way that we can really protect it is by keep speaking out together.
So perfect.
Mm-hmm.
You have any other questions for her, Stuart?
No, I think it was very interesting. I think you probably have an interesting vantage point of seeing how this work is done. And something that I always come back to is like, I wish more of the general public could see how this work is done, because I feel like a lot of people have a very inaccurate picture in their minds of what advocacy looks like and the kind of people that are involved. And, I just wish that, I almost wish it was like a requirement in public school that you take on a project like and advocate for it for a summer, because I think it would give people a better understanding of like how serious the work is and how you have just this very diverse group of people from different walks of life and different interests and working to advance whatever it is to protect their health or their community or their environment. Hearing you talk about the water in Pittsburgh like made me think of that.
Yeah. I think people often have a limited idea of what advocacy looks like. You often think about the person with the microphone who's marching or giving speeches at City Hall, and it totally can be that, but it can be so much more. It can also be the artist who leaves murals around the city, right? It can be the kid who has a conversation with their grandparents or parents about how they're feeling, right? There's so many different ways to be in a space where you're just like making change, right? And we all can play different roles, whether it's, diaper drives, talking to your local school board, focusing on something and really digging in. If we all did that, just found a way to make our community better in some space, then I think we wouldn't have as many problems as we have today.
So true. And I feel like I have less problems and stress because of you and Andrew and Addison. I also want to say Megan's great, and I'm grateful to Michael for allowing all of you to offer so much support to all of us here living on the front lines. And just a lot of respect and gratitude for you all. Thank you so much, Brooke.
Same for you too. Yeah.
Stuart.
Thank you.
Guidance and protection.
All right.
Peace.